Hello, family. Welcome to A-Level Law. And today we're going to be looking at the difference between civil and criminal law. So let's get right into it. Now, what is civil law? Right? So when we think about civil law, we are thinking about law that has to do with things like divorce, like people fighting maybe over money, over contracts. They promised each other that you're going to do this job and you're going to get this amount of money, and then somehow the other person didn't pay the other person. Or things like you get into a car accident with another vehicle, and who has to pay who is wrong, whose insurance has to pay the money, and all of that. So all of those things are part of what we call civil law. So let's just try to define what civil law is. Now, civil law is also called private law. This is because it deals with disputes between private entities. When we say entities, we mean people like you and me and companies and organizations. It deals with disputes between those entities, people and business and companies and other companies, organizations and other organizations. So it is called private law because it is dealing with private entities. Now, it is a branch of law that deals with disputes between individuals, organizations, or both. So common civil law cases include contract disputes. Like I was saying before, maybe you paid someone to do something and they didn't do it, and now they don't want to return the money back and all of that. It deals with that. It also deals with family matters like divorce, right? People no longer want to be married, and now we have to look at who's going to take the kids, who's going to take the car, how is all of these things going to work. It also deals with situations it also deals with a part of law which is called the law of tort. So the law of tort or tort is an area of law that concerns with a wrongful act for which civil liability is incurred. So what that statement just basically means is a wrongful act would be something like we get into an accident, I was wrong, I smashed your car in that accident, right? So that is a wrongful act, and I am liable. I should pay for that car. I should pay for the damage that was been done to your car. So that's what we are looking at when we are talking about the law of tort. So it's about wrongful acts, and it's about liability, which means I am responsible for paying for the car that I've damaged. So that's basically the law of tort. We'll talk about it in later videos. Now, what is the purpose of civil law? Now, the purpose of civil law is to resolve disputes and provide remedies to the aggrieved party. So the person who has been wronged, who has been put at a disadvantage, who has had their car destroyed, or a person who has been duped in a contract, they have been conned, they have to get some remedies, and that's why these are the aggrieved parties, and that's why we have civil law. Usually, how the remedy, right? A remedy is a solution to ease whatever damage that was done, right? To compensate you. Usually, it's in the form of compensation, which is like money, or you have to buy the thing that you destroyed, or you have to pay money, or it has to be specific performance. So you are directed to go and do something by the court that's called specific performance. Now, what are the parties in the civil case? If there's a civil case before the courts, what are the parties? We have the plaintiff and the defendant. So on one hand, we have what is called the plaintiff, and then on the other hand, we have what is called the defendant. So the plaintiff is the one who's complaining and saying, you did this wrong to me. And then the defendant is like, no, I didn't do it. So there's the parties. Now, let's look at criminal law. Now, criminal law, it deals with offenses against the state or society as a whole. So it's when you rape one person in society, you have offended the society as a whole. you have gone against the society as a whole. It affects the whole of society, right? It's different from the civil law where it's just between you and the other person. Now it's dealing with crimes, things like theft, like stealing, like robbery, like murder, like rape, things like that. Those are crimes. So criminal law, it deals with offenses against the state or the society as a whole. Now let's look at one thing before we talk about the purpose of criminal law. I want to talk about public law. So public law is the law which deals with the relationship between the government and its citizens, as well as the government's powers and limitations. So public law is about the relationship between the government and its citizens, right? How much force should the police use when they are arresting someone? That's part of public law, right? So it is between the state or the government and you as an individual or as a person, right? So criminal law is part of public law because crime is regarded as an action against the state or the society as a whole. So we consider it as public law because you're going against the state or the society as a whole. Now, the purpose of criminal law is to maintain public order, for there to be order and safety. And we do that by punishing individuals who commit crimes. So examples of crimes I've already given you: theft, murder, assault. You just hit someone, boom, boom, boom. You hit somebody, that's assault. Fraud, right? All of that is examples of criminal law. Now, parties in a criminal state. Now, bear in mind that we are focusing, the principles that we're learning are the same, but we are mainly zeroing in the details of the law of England and Wales. So that's why you're going to hear things like Crown Court or Crown Prosecution Services, things like that. So the parties in a criminal case, the state will be representing the government or the state, right? That's the state. And we have the accused, the person who's being accused for doing the crime. So the state is represented by the Crown Prosecution Services. So we call them prosecutors, right? So the Crown Prosecution Services of Wales and England are the ones who will be representing the state, right? They will be prosecuting the person who offended and saying, you did it, you are supposed to go to prison. And then the victim, for example, a person who has been assaulted, they've been hit, or a person who's been raped, they are not a party. They are not fighting anyone in court. They are mainly, they are basically an evidentiary tool or a witness. They are used for evidence to say, did this happen to you? Because when it comes to crimes, it is the accused against the state, or the state versus the accused. Now, let's look at the procedures in civil cases. How do things happen? What is happening really if you're getting into court and there's a civil case? Now, civil cases are typically heard in the county court or the high court. So if we're looking at England and Wales, we are saying the civil cases will be heard in the county court or the high court. And then depending on how complex, how difficult the case is and what are the complexities they are, and the value of the case, how much money are we talking about is involved in this case, right? If it is high value and it's very complex, it will go to the high court. If it is low value or it is less complex, it will go to the county court. And the procedure here is less formal than criminal trials. So the procedure is not very formal. There are not so many too many tight rules that we have to follow this. Like, there are rules, but they're not as formal as when we're looking and comparing it with criminal cases. And then cases are sometimes resolved without a full trial through settlement and mediation, right? So sometimes the case doesn't have to go before a judge and go through all the process of the trial. Sometimes people sit down and there is a mediator, someone who's appointed to mediate, to make them reconcile to each other and get to an agreement before they even get to the trial, where they have to debate in court and they have to have a lawyer and things like that. So that can happen. Or sometimes it's also called a settlement, where people sit down and say, you know what, this is what you are saying I owe you. You're saying I'm owing you $100,000. What if I give you 90? Can we just settle it? So sometimes that happens in a civil case. Now, so in fact, when it comes to civil cases, you actually have to exhaust all other possible methods before you go to trial. Otherwise, you put a lot of burden on the court system to be deciding every small issue, or every issue that could have otherwise been dealt with outside the court. So you have to actually use all the other options. When there's no other way to resolve the issue, that's when you then go to trial. So you have to use mediation, you have to talk, you have to try to reach an understanding before you go to trial. Now let's look at procedure in criminal cases. What is the procedure in criminal cases? So criminal cases are usually heard in the magistrate's court for the less offenses, right? Less serious offenses. Then for the more serious offenses, they are heard in the Crown Court. This is for more serious offenses. Now, criminal trials involve a more formal procedure. So there are many rules that have to be strictly followed in how you run the case. So it often has a jury. So a jury will be a number of people who will be sitting, and you would have to convince them, because they're the ones who are going to vote on whether a person is guilty or not guilty. In civil cases, right, parties can choose whether they will have a single judge or a jury. But in criminal cases, you can't have a single judge for the most part. So in civil cases, you can choose whether you're going to have your case heard by one judge or a jury of many people who are going to make a decision. But in criminal cases, you usually don't have that option. Usually, you can't have one single judge for most cases. Now let's look at the burden of proof. The burden of proof is, what we mean by that is, who should prove that they are correct and that they should win the case? Who should prove that? In a civil case, who has the burden of proof? What we have is the plaintiff. The plaintiff is the person who's going and saying, who's complaining, or the claimant who's claiming something. It's the same thing. So the plaintiff has the burden of proof. He is the one who has to prove that this person wronged me, and therefore I have to be compensated. I am claiming 1,000 because he smashed my car. So the plaintiff has the burden of proof. In a criminal case, the prosecutors, the ones who are accusing someone that they did something, they raped someone, they stole someone, they are the ones who bear the burden of proving it. They are the ones who have to prove to the court that indeed this person did it. How far should you prove your case so that you win it? All right. So for example, in a civil case, how far should the plaintiff, the person who's complaining, to say, I have been wronged, how far should they prove that they have indeed been wronged? So in civil cases, it is a balance of probabilities, which means it just has to be more likely that what you're saying is true than not true. Make sense? So the burden of proof, how far you have to prove in a civil case, is you just have to prove that your version of the truth is more likely the correct one than the other party's version of the truth or of what happened. But in a criminal case, the prosecution has to prove beyond reasonable doubt. Beyond reasonable doubt. A reasonable person should not have a doubt, right, after the case has been presented to them, that the accused person did what he is being accused of. So when it comes to criminal, the prosecution has to prove their case beyond reasonable doubt before someone is sent to prison. Now, we want to look at the difference between civil and criminal law. Let's look at the purpose. What is the purpose of civil law? What is the purpose of criminal law? Civil law, it is to uphold the rights of individuals. right? To say, I have a right to my car. I have a right to not have my salary just taken away like that. I have a right to not have someone just destroy my car and just go away and not pay for it. That's my individual right. So that's the purpose of civil law. But when it comes to criminal law, it is to maintain order and to protect the society. Now, let's move on. When it comes to the person starting the case, who starts the case? In civil law, individuals whose rights have been affected are the ones who go to court and start the case. In criminal law, it is usually the state through the Crown Prosecution Service. You will understand later why I said usually, but for now, understand that most cases it is the prosecution through what is called the Crown Prosecution Services. It has a different name in different countries, but for the sake of our studies of English, the law of England and Wales, it is called the Crown Prosecution Service. Now, what is the legal name? Difference number 3, the legal name of the person starting the case. In a civil law, the person who starts the case is called the claimant. He's the one who's going to the court and saying, I am claiming this from this person because of this, because he smashed my car, so I'm claiming 1,000 to fix it. But in a criminal case, the person who starts the case is called a prosecutor, right? They are the ones who are told by the police after a person reports to say, there's a person and who committed a crime, prosecute them, go to the courts and prosecute them. So the person who starts the case in a criminal case is called the prosecutor. Now, let's look at the next difference, the courts. Right? In civil law, the county court or the high courts are the courts that deals with civil matters. In criminal law, the magistrate's court or the crown court is what deals with the matters. Now, we've already talked about the standard of proof. The standard of proof in a civil case is called a balance of probabilities. So, if you go to the court and you want to prove your case, you are the claimant, right? You're the one who's saying, I've been wronged. How far should you prove your case? It should be on what is called a balance of probabilities. What this means is you just have to make the court believe that it is more likely that what you're saying is what happened than it is likely that what the other party is saying happened. So that's how you have to prove it. But the standard is higher in criminal cases because in criminal cases, this involves sending someone to prison. So in a criminal case, the prosecutor has to prove beyond reasonable doubt. A reasonable person should not have any doubt, should not have a doubt that what the prosecution is saying is the correct thing. This person actually committed the crime. Then looking at the person who's making the decision. In a civil case, it is the judge. In a criminal case, it is called the magistrate or the jury. Now let's look at the next difference, the decision. The decision that is given in a civil court is whether a person is liable or not liable. What that means is whether a person is responsible for what happened or is not responsible and they should not pay. So usually, if a person is found responsible for damaging another person's car or responsible for not paying someone what they are supposed to be paid, they will be found liable. Or if they are not found liable, then it means they don't have to pay anything or they don't have to do anything. Because remember we said when a person is in the civil court, they can be instructed to do something which is called specific performance, to give something, or to even pay someone money. So if they're liable, they will pay. In a criminal court, the decision is to find the person guilty of the crime or not guilty. Now, what are the powers of the court? Let's look at the next difference, the powers of the court. So in a civil court, usually an award of damages is given. So you did something wrong, so the court says you have to pay that person that you did something wrong to a certain amount of money, which is called damages. Or you can be asked to do some specific thing or to let go of something. That's what is called specific performance. It could be in a contract where you're told that go and pay them what they are, go and give them the the car that you're supposed to give them, or go and do the job that they paid you for, that specific performance. So we will look at all the other examples of rescission and rectification. Those are some of the things that the civil court can make a person do as part of their judgment. Let's look at criminal. In a criminal case, a person can be confined to a prison, to be sent to prison, or to be asked to pay a fine, or to do community service, or they can be declared not guilty and they'll be discharged and let go to live their best life. Okay, congratulations. You have reached the end of this class. Congratulations. Welcome. Well done. Well done. Well done. Well done. If this is adding any value to you, please do me a favor. Just click that subscribe button, that like button. It helps us to keep doing what we are doing. And if you also want to be part of our online school, we offer A-level law, we offer IGCSE subjects, we offer A-level subjects. It doesn't matter where you are. We work with people from all over the world, and this is an amazing community. We do one-on-one classes and small group classes, and we have amazing platforms. So just check the details in the description of the channel or in the description of this video to get that information. Until next time, peace.